A very warm welcome to the London Shipping Law Centre YMP 4PAM Court event on soybean cargo claims, common themes and key takeaways from recent decisions. This event has been tremendously popular and I'm very pleased to see so many of you today. Many of you will know me and will be familiar with the London Shipping Law Centre and the YMP, but for those who aren't, I am Francesca Cappa. I'm currently the chairperson of the Young Maritime Professional Association. The YMP is a London-based social networking professional association which was set up by Dr. Aleka Shepard in 2011. To promote and support a young maritime professional across the industry. I would like to take this opportunity to thank Dr. Aleka Shepard for her unwavering support to the YMP and of course, to all our events. The YMP is part of the London Shipping Law Centre, as I mentioned, and our aim is to promote cross-sector networking, education, exchange of ideas, and further professional development. We run events from webinars, discussions, short talks on site, and also support social events. Of course, the pandemic has been very challenging for us, and we have all missed in-person events. But one of the blessings for us has been the fact that we've gone virtual, and we've been able to broaden our horizon and to reach a wider and more international audience. Despite the different time zone, I'm very pleased to see delegates from a number of countries joining us today. And before we get started, I would like to thank 4PAM Court for co-hosting this event today. And of course, in particular, Anna Hoffmann for all her efforts and work in putting together today's event. And finally, I really would like to thank all the speakers for their time and incredible efforts. I know how much time and preparation goes to put together such events. So thank you all once again from myself and from the YMP committee. I shall now hand over to Anna Hoffmann. She's a barrister at 4PAM Court. Many of you will know her. She specializes in international commercial dispute resolution, and she's a member of the YMP committee.
Thank you so much, Francesca. I am incredibly pleased to be here and very grateful that YMP and the London Shipping Law Centre are co-hosting this event with us. It's great to see so many people here, and indeed, as you say, it's a great advantage that we can have so many people joining us from different locations. A very warm welcome to everyone who's here today and from slightly cliche rainy London. I hope it's not too loud in my background. I should briefly say a few things on logistics. This webinar is being recorded, just so that everyone is aware. And there will be ample opportunity in the end for questions and answers. We have decided that this should be a very interactive event, so we'd like to hear from you. It's very much a practice-focused event, so if you have any questions, please put them ideally in the Q&A box. But we'll also monitor the chat. That is always slightly confusing with Zoom. There's the chat and the Q&A. But if you could put your questions in there, we'll try to answer all of them. I will also introduce the panel briefly. I think the full biographies were sent around beforehand. We have a truly stellar panel here with great expertise. And what I'm especially pleased about is that we have so many different perspectives to really bring you a broad spectrum of ideas and expertise on this issue of soybean cargo and generally cargo claims. So just in the order as they appear on the biography listing, if you have that in front of you, we're joined today by Ian Gaunt, who's a full-time arbitrator in international maritime cases and a past president of the London Maritime Arbitrators Association, the LMAA. And he's been actively engaged as an arbitrator in cases involving international shipbuilding and ship sale, and also soybean cases. He is also the co-author with Simon Curtis and William Cecil of the 5th edition of the Law of Shipbuilding Contracts. And we're also joined by a second arbitrator, Ben Goss. He's a maritime arbitrator and mediator. He's got a commercial background in shipping, and that includes chartering and sale and purchase of vessels and shipbuilding and finance. And he's a chartered shipbroker. And Ben is a fellow of the Chartered Institute of Arbitrators and the Institute of Chartered Shipbrokers, and a full member of the LMAA. We're also joined today by Alexander Wright, QC, who's a silk at 4 Pump Court. He's widely recognized to be a leading practitioner in the shipping world. I'm sure many of you are familiar with him. In 2020, as a junior, he won the Shipping Junior of the Year at the Legal 500 Awards, and he has acted in many of the most important and substantial shipping disputes in recent years, including for the successful charters in both the Thai Price and the Eternal Bliss in the Court of Appeal, and we'll hear something about those decisions. Darryl Kennard of Penningtons, Manches Cooper, is a partner in the Marine Trade and Energy team in the London office and a key member of the emergency response team. He is one of the few shipping lawyers who specializes in both wet and dry work. And he was based in Norway for a while and in Singapore for longer. And he receives instructions from salvors, container liners, dry bulk and tanker owners, as well as from charters, traders, P&I clubs and insurers. And last but not least, Ian Clarke is here, who is the head of claims and regional and a director of the West P&I Club's office in Greece. He's a practicing English and solicitor and admitted to the Prayers Bar. He has over 30 years experience working in P&I clubs and in private practice. So you'll see we have a truly wide range of experience, and it's my very great pleasure to hand over to Ben now, who will introduce the cargo and why we're talking today about soybeans.
Thank you very much, Anna, and thanks also to Francesca and to the LSLC-YMP and 4 Pump Court for inviting me to participate in today's event. I'm going to kick off with by putting my sort of researchy hat on for 5 or so minutes, and to provide a quick introduction to soybeans as a commodity, and which we think provides a bit of sort of context for the legal issues that we're going to go on to talk about. So soybeans are a type of grain cargo, accounting for about 30% of total grain cargoes and around 3% of total dry bulk trade, which you'll see shortly translates into quite big volumes. Soybeans are an oil seed. The oil has a variety of uses, including human consumption as vegetable oil and margarine, for example, as animal feed, and in the plastics industry. According to a 2013 article published by the Earth Policy Institute, it wasn't until well after World War II that soybeans gained agricultural prominence, enabling it to join wheat, rice and corn as one of the world's 4 leading crops. The rise in demand for soybeans has been meteoric, following the discovery by animal nutritionists that combining 1 part soybean meal with 4 parts grain, usually corn, in feed rations would sharply boost the efficiency with which livestock and poultry convert grain into animal protein. As China's appetite for meat, milk and eggs has soared, so too has its soybean meal, which is mainly used as pig feed. Its fast-growing poultry industry is also dependent on soybean meal, and China uses large quantities of soya in feed for farmed fish. In '95, China was producing 14 million tons of soybeans and consuming 14 million tons. In 2011, it was still producing 14 million tons of soybeans, but it was consuming 70 million tons, meaning that 56 million tons had to be imported, and that figures continue to widen since. China's neglect of soybean production reflects a political decision made in Beijing in 1995 to focus on being self-sufficient in grains, coarse grains and wheat. China decided it didn't want to be dependent on the outside world for its food staples. By strongly supporting grain production with generous subsidies and essentially ignoring soybean production, China increased its grain harvest rapidly while its soybean harvest languished. Soybean crushing capacity was constructed in coastal locations to be supplied by imported beans, with the resulting oil used for human consumption and the residual meal for livestock. So this slide was provided by Maritime Strategies International, MSI, who are an independent maritime forecasting and advisory services group based in London. And they were kind enough to provide a couple of slides that capture nicely the recent developments in soybean trade over the past 20 years. The principal effect of all of this soybean consumption has been a restructuring of agriculture in the Western Hemisphere, with more land dedicated to soybeans. The United States, Brazil, and Argentina account for over 4/5 of world soybean production. And for 6 decades, the US was both the leading producer and exporter of soybeans. But in 2011, Brazil's exports narrowly eclipsed those from the US and have far surpassed them ever since. So this slide here shows the volume of soybean imports and exports from 2000 to 2021. Imports on the left and exports on the right. So looking first at the left, you've got China shown in dark blue, rest of Asia in yellow, Europe is in green, and light blue is rest of the world. And what you can see is that China accounts for the doubling of global soybean imports. Sorry, back one, Anna, thank you. The doubling of global soybean imports, which have gone from just under 100 million tons annually at the turn of the century to over 200 million tons in 2021. Europe and the rest of the world import volumes have remained relatively consistent, whereas China went from importing very few soybeans in 2000 to just shy of 100 million tons by the 2020s. What the left side of MSI's slide shows us is that Brazil has continued to provide, sorry, the right side is a continuing, Brazil has continued to provide an increasing share of global supplies. The rise in long-haul trade from Brazil's China has been a key factor underpinning the performance of the dry bulk market. Recently, the spread of African swine fever amongst China's swine herd has dampened Chinese import requirements, but this is expected to only be temporary. Next slide, please, Anna. So a key feature of the soybean trade is its seasonality. Weather and seasonal patterns affect the volume of production and timing of the harvest. Shipments from Brazil typically peak in the second quarter of the year, and shipments from the US peak in the fourth quarter. Argentina has 2 soybean crops per year, and Uruguay, soybeans are usually harvested in April and May. Government policy shapes trade flows. So a trade war between the US and China dented US peak season shipments in 2018 and 2019, before a resolution in 2020 initiated a significant uptick in volumes traded from the US in the second half of the year. The war in Ukraine will also affect the composition of grain trades globally, with a small share of planted areas otherwise designated for soybeans for export now more likely to be used to grow corn to offset the loss from Ukraine. So how are soybeans processed? They're first cracked in a crusher, broken into small fragments, which are then steamed. Steaming makes the fragments soft, enabling them to be rolled into flakes, which releases oil, which is then extracted using a solvent. The crude oil that's extracted from soybeans can't be used directly and must be further refined to make an edible oil, which involves degumming, which is basically the removal of chemicals known as free fatty acids from the crude oil. After the oil has been extracted, the high protein soya flakes that remain are, after further processing, valuable as animal feed and commonly referred to as soybean meal. The quality of the soybean that's sent for processing directly affects the quantity of oil that's extracted and the quality of the soybean meal that remains. And for that reason, soybean cargoes are often subject to spoilage and contamination claims. Generally speaking, while some determination of quality might occur between harvest and loading, it's usually only on loading when contractual samples are taken by the shipper and seller of the cargo. But that's to satisfy a condition of the sale contract, not the contract of carriage. Different countries have different quality standards, and it's not uncommon that soybeans are sold under a contract that incorporated a South American quality standard, and are accepted for import based on a Chinese quality standard. Typical parameters for measuring the quality of soybeans include the percentages of moisture, crude protein, crude fat, protein solubility, free fatty acids, odor, color, impurities, damage. There's a whole raft of parameters that determine the quality of a soybean cargo under a sale contract, any of which can form the basis of a challenge by the receiver of the goods, at discharge. Meanwhile, the master will issue a clean on board bill of lading based on the apparent good order and condition of a cargo, as observed with the naked eye during loading, so far less scientific. Some of the key characteristics of soybean cargoes, they're liable to heat and or sweat, especially if damp, when they may germinate or start to rot. So they require careful pre-planning, inspection, carriage and ventilation. Grains in bulk generally, and soybeans especially, are prone to surface movement, shifting at sea, which is why the carriage of grains by sea is subject to strict scrutiny and regulation. Another feature of grain cargoes is that they're prone to infestation from various insects, commonly referred to as weevils, and therefore require regular fumigation, which often takes place immediately after loading in the vessel's holds. Ian Clarke, I think, is going to talk further about the sort of hazards and P&I Club guidelines to address these. So I'll hand over to you, Ian.
Thank you very much, Ben, and it's a pleasure to be with everybody today. I think really there are 3 things that we need to remember about soybeans. And the first one is that they're round, the next is that they're moist, and finally that they do contain mold. So how do this trinity interplay with one another to result in some of the problems that we have seen? So if you think of soybeans as small balls, which effectively they are, when they're put into a hold, they will have interstitial spaces between them, because of course they're not square. There are of course going to be little spaces around them. They're also slightly moist. And of course, the air that is surrounding those soybeans will have some degree of moisture as well. And what's important for us to look at in that area is the relative humidity in the interstitial spaces. And that is the amount of water as a percentage of how much the air can hold at that particular temperature. So higher relative humidity in these interstitial spaces allows the mold, which is an inherent characteristic of soybean cargoes, to grow. Now, as that mold grows, it causes heating, and of course that results in the cargo deteriorating and starting to blacken. So we have to look very carefully when cargoes are being loaded about the temperature and the average moisture content. But what's important to remember is that you will only be provided with an average moisture certification from the load port for the whole cargo which is going into the ship. So it could comprise many different parcels, and some could be above average moisture levels, some could be below. So therefore there may be patches when you're looking at any form of heating. Now, if you get 65% or more relative humidity, you're likely to see increased growth of the mold, and therefore self-heating and deterioration. But that will continue until the cargo is discharged. Now, some of that heating and deterioration may have already started while the cargo has been on shore and been in the silos. So it's very difficult to be precise about when that cargo may turn into one which is more particularly deteriorated. There are, however, tables which can give guidance on based on the temperature and the moisture content to indicate how long a cargo may reasonably be on board a ship for reasonably safe carriage. Now, bear in mind that cargoes going from South America through to Europe will be on board the vessel for around 14 to 20 days, and in China, 35 to 45 days. And what we will probably talk about later are some of the issues regarding delay and the causes of those delay and what the impacts may have, and therefore some of the responsibilities that arise from it and who bears the liability for some of those issues. So I've put up a few slides here, pictures in slides, and you can see that the cargo, when it has started to deteriorate, is a rather unattractive mess. It tends to blacken. Now, the soybeans can get in to temperatures exceeding 100 degrees Celsius. And it's not that the cargo is actually burnt, although it is usually referred to as being burnt, it's actually just blackened. And in the picture on the left, and the one with the bulldozer on the right, that you can see, those two cargoes are not giving off smoke, but it's actually steam, and that's the water vapor which is coming off the cargo. You may also find that there is sweat damage on the surface of the cargo, and that is something which is material for ventilation as well. So how do we look at these to try and minimize the problems that can arise? Firstly, it's important to take temperatures on loading and throughout the voyage. Fumigation will also have taken place. Ben mentioned that there are normally the presence of weevils in this type of cargo. And there'll also be ventilation. Now, there's an old rule which is hot to cold, ventilate bold, cold to hot, ventilate not. But we normally refer to that more scientifically as being a 3-degree rule, when ventilation should normally take place when temperature outside the holds is 3 degrees above or below the temperature on loading. So if there are variations in the temperature and there are concerns by the owner of the vessel, then it's important to protest. Also follow the charterer's instructions on how they want the cargo to be carried and ventilated, and appoint surveyors and experts on the discharge to immediately attend. The sooner we do so, the easier it is to look at segregation of cargo, which may have been damaged, and also look at the causes of that damage. It could be just ship sweat. There may be other issues such as saltwater ingress because there was a rough voyage and the hatch covers leaked. So all of those issues need to be investigated in full by competent surveyors. On discharge as well, it's very often, particularly in China, we will see large claims arise. The cargo claimant may be coming up with claims for the full value of the whole cargo. That could be 30, 40 or more $1 million. And of course, as a P&I club and our members having issued the bills of lading as carriers, we look carefully about whether we are prepared to provide security for those claims. And one of the immediate things we'll look at are the value of the vessel, because that's all that could be attained upon auction, and also limitation. And in particularly in China, we see that very large claims are made, and we tend to put up a club letters of undertaking if we can, alternatively alternative security through PICC or other Chinese insurers for much, much less. I mean, we may be looking at $6 or $7 million. And of course, those claims then have to be negotiated and concluded, and there will be very careful attendance to look at the salvage sale of the cargo, whether there has been any remediation, and indeed whether some of that blackened cargo or the affected cargo that's more mildly affected can be remediated or processed and put into the process very slowly. And that's what Ben had talked about with the oils that are produced. Now, they may have a lower value at the end of the day, but those are things that we will look at from a pure claims handling perspective. Naturally, we will also look for any recourse actions, and the interclub agreement may apply. We'll look for cross securities from the charterers club. We'll put the charterers on notice, and there's a very specific formula for that within the ICA. And we will also try to ensure that the charterers are as engaged as they can be in this process and approve any settlement that we may reach so that they can't say it has not been reasonably settled. We may also look at things like anti-suit injunctions with the charterers, and others will touch upon these issues later. The ICA can still also apply to shortage or wet damage, which will operate quite independently of any of this type of damage. If you're going to look at 100% apportionment under the ICA, then there must be clear and irrefutable evidence of the act or neglect of one party or another. And this is the area where we tend to have a lot of arguments about ventilation which really can only affect the surface of the cargo. It can't penetrate any deeper, and is really not a particularly great argument on the part of charterers. Or they may come up with arguments that it's bunker heating below the cargo which has precipitated this problem. All of these are evidential issues that need to be looked into very carefully. So I will also leave it there, but just make one further point that we can discuss Hague-Visby rules in other jurisdictions, but if you're talking about China, sadly, the inherent vice defence is not one that is going to be applicable. So I'll leave over to Anna, and there's some more details on this on the next slide as well.
Thank you so much, Ian. We will send around the slides, I should say, and thank you so much, Ian. It's really invaluable to have your perspective here. I know after a YMP event on some court decisions involving soybeans after Christmas, we had lots of questions. So we've heard already from Ben that there are lots of shipments going to China, and we decided to pay special attention to that and to have a focus on jurisdictional issues involving China as well. So if I could hand over to Ian Gaunt, please, to say a few words about that.
Thank you very much indeed, Anna, and thank you for inviting me to this webinar today. I wanted to say a few words about the situation in China and how it differs, particularly as regards jurisdiction, to the position in the UK, or more specifically England and Wales. And this very much affects, I think, the tactical strategic handling of soybean cargo claims. And the reason for mentioning China in this context, I think, has already been indicated by Ben in the bar charts which he showed, that of the 100 million or so tons of soybean cargo, which is exported, particularly from Brazil and the United States, something like 60% of the volume in terms of this world trade is exported to China. And many of you who've been involved in cases concerning anti-suit injunctions will know that many of them, in fact, stem from challenges to jurisdiction in the Chinese Maritime Court in cases brought by receivers in China in the Chinese Maritime Courts, where they hope they will be able to establish jurisdiction. And I wanted to point to a number of differences between the approach of the English courts and the Chinese courts in terms of the incorporation of the arbitration agreement taken from a charter party into a bill of lading, because this is, I think, at the root of the collision between jurisdictions, which very often give rise to applications for anti-suit injunctions on the one hand and possible proceedings in China on the other. You'll probably all be very familiar with the traditional English approach to the incorporation of arbitration agreements into bills of lading. This is a tradition which goes back a little over 100 years now, from the famous House of Lords case of Thomas Portsea. And one sees over the years a relatively flexible approach by the English courts to incorporation, and the establishment of the now very well accepted principle that general words of incorporation may be sufficient to incorporate terms of the charter party which relate to the contract of carriage, i.e. the specific process of carriage of the goods. But in order to be able to incorporate an arbitration agreement from the charter party underlying the bill of lading, then you will have to have special words of incorporation. And most of the standard forms now indeed do incorporate those standard words. If I look at the Congen Bill 2016, for example, on the second page or the back of the bill of lading, you will find in the conditions of carriage all terms and conditions, liberties and exceptions of the charter party, dated over leaf, including the law and arbitration clause or dispute resolution clause, are herewith incorporated. And that will, in most cases, as a matter of English law, be sufficient to incorporate the arbitration agreement and to give jurisdiction to an arbitration tribunal in preference to a court. But that may not necessarily be the position adopted by other courts. So the English courts are not only relatively willing to allow parties to rely on the arbitration agreement from the charter party when litigating or arbitrating under the bill of lading, but they are also very often prepared to manipulate the wording where the parties have not got it right, or there is a pathological arbitration agreement. And this is also the case as between, for example, jurisdiction clauses, court jurisdiction clauses, and arbitration agreements. So you will see, for example, in cases like the Channel Ranger, that Mr. Justice Males in that case was really quite flexible in terms of the manipulation which the court would apply. And looking further afield, in Hong Kong, we find that, as reiterated in a relatively recent case in Hong Kong, OCBC Wing Hang Bank Limited against Kai Sen Shipping Co. Limited in 2020, that the Hong Kong courts have essentially adopted and restated the English law approach. So Hong Kong, of course, is now part of China, a special administrative region, but the position adopted in mainland China by the PRC courts is in fact very different. And a good statement of that can be found in the journal Arbitration International in 2017 in an article by Liang Zhao and my former colleague Lian Jun Li, and also in their book Maritime Law and Practice in China, which I would commend to you. This is dealt with at pages 75 to 77. If I hold that up, some of you may be familiar already with this book, but it contains a useful summary of the position as it was in 2017, and I'm assured by Mr. Lee that it has not changed greatly since then. So if we could have a look at some of these areas in which the PRC courts have a different approach. If I could have the next slide, please, Alan. So first off, really, the PRC courts are more restrictive in determining issues relating to incorporation of arbitration agreements into the bills of lading. And this may well be seen as being a local preference for the local party, namely the receiver of the goods in China. So the Chinese courts have established, and these are usually the result of requests for opinions which are made by the maritime courts to the Supreme People's Court. And although these may not be universally binding, as there is no real system of precedent in China, which is equivalent to that in England and Wales, nevertheless, these must be treated as being pretty authoritative statements, as they come from mostly the Supreme People's Court. And the first is that unless the incorporation clause expressly provides that clauses such as the arbitration clause are to be incorporated into the bill of lading, they will not be binding on the holder of the bill of lading, who will normally be the receiver. That's not so much different from the traditional English approach, that you have to have specific words of incorporation in order to incorporate the arbitration agreement. But then other courts have found that words incorporating the arbitration clause have to be stated on the front page of the bill of lading and not normally on the back of the bill of lading. I showed you the provision in the Congen bill, which is on the back of the bill of lading, where the conditions of carriage are stated, and where it's stated that the arbitration clause from the charter party referred to on the front page are to be incorporated. It would seem that that may not be sufficient in China to incorporate the arbitration clause. The second point, or the next point, is that words have to be in a notable form different from other clauses. You might say, well, it has to be therefore in block capitals or in bold lettering. Again, that's not provided for in the standard BIMCO form of Congen bill. So you may have to adapt your bill of lading in order to make specific provision for that. The third, next point is that the date of the charter party and the parties to the charter party have to be stated. Now, the Congen bill makes provision for the date of the charter party in one of the boxes on the front page, but it does not make any specific provision for who the parties to that charter party are, and therefore it would be regarded in many cases by the Chinese courts as being insufficient to incorporate the arbitration agreement. Can I have the next slide, please? And there are two more final points. The arbitration agreement will not bind an insurer claiming under the bill of lading by subrogation. Now, this is fundamentally different from the English position, which would accept the right of subrogation, and indeed the fact that the arbitration agreement in the bill of lading, or incorporated into the bill of lading by reference, will be binding by subrogation on the insurer claiming under the bill of lading. And then finally, a distinction has been drawn between arbitration clauses contained in time charters and voyage charters. The approach of the Chinese courts appears to be that a time charter is a form of leasing contract. It's not really a contract of carriage as such. The contract of carriage may be in the bill of lading or in a subsidiary voyage charter, but a time charter might not be regarded as being a type of charter from which the arbitration agreement can be incorporated into the bill of lading by reference. Now, that's been held to be wrong by the two authors I mentioned as a matter of principle, but it nevertheless it appears to be the accepted jurisprudence on the basis of the reply of the Supreme People's Court in China at the moment. And it may cause a particular problem, it seems to me, in the case of time trip charters, which are in many respects similar to voyage charters. Is the Chinese court going to say that if you have a time trip charter, which is in effect for one round voyage, or time which is corresponds to a particular voyage, not going to be an acceptable basis for importing an arbitration agreement into a bill of lading? So there are many, many pitfalls there. I think to wrap up, it seems to me that certain things, certain aspects of the sufficiently clearly on the front page of the bill of lading and not on the back of the bill of lading. As I've mentioned in the three cases I mentioned in the previous slide, by naming the parties to the charter party on the front page of the bill of lading, by making a specific reference to London arbitration in block capitals, if at all possible, you may enhance your chances of the Chinese Maritime Court accepting that it does not have jurisdiction, and that the jurisdiction is held by an English maritime tribunal. So those are some practical points which might need to be considered. And at this point, I'll hand over to Darryl Kennard, who will tell you about many more aspects of these cases, particularly anti-suit injunctions as they impact on these situations, and some suggestions as to how you can improve your chances of winning. Thank you.
Thank you very much, Ian, and thank you to everyone for inviting me along. I think I should qualify that I hope to improve your chances of not losing so badly rather than winning. Winning is something that is often out of all of our grasps, and ultimately we're collectively in the game of risk management and trying to resolve the claims on as best economic terms as possible. Claims in China, but there are a couple of pointers, I think. The first thing is to appreciate that foreign experts their evidence is not admissible in English law, under Chinese law rather, but they're invaluable to get in a first-class expert that we all know, and they can guide local experts and ensure that the quality of the local experts' reports are good. And I'm pleased to say that we had some feedback from CWA during the course of this talk to say that they've managed to successfully reduce a Chinese claim by 50% on the basis of inherent vice. So you can fight in China and you can get partial victories. Going for an outright victory in China may well be elusive, but there are ways of handling the claims in China, and getting the evidence is key. Getting people on the ground early is key, and linking up your foreign experts with your local experts is key. But very often, as we all know, large claims are still saddled upon the owners, and of course there are means and ways that which they can claw back some, possibly all of that money. I think the first weapon in a ship owner's armory is the anti-suit injunction. I've often heard it said to me by some clubs that spending money on lawyers in England to go and get an anti-suit injunction is a waste of time and money, because the anti-suit injunction will be ignored. I think it's a fair comment when you look at it from a statistical perspective, but I think it's actually sometimes a bit of a wasted opportunity. I've probably in my time got 10 anti-suit injunctions, of which 2 have been complied with. The most recent was a year or so ago for a claim that was valued by the Chinese claimant at least for $10 million. And so that $10 million claim fell away. We commenced in parallel an action in London. The Chinese claimant, recognizing that the defense of inherent vice was going to bite in the London arbitration proceedings, essentially folded, and so the claim was eradicated. Now, if you think about that from a different statistical perspective, a saving of 10 million, well, let's say the claim was exaggerated and you might have only gone down for half of that in a Chinese court, a saving of $5 million, you can apply for very many anti-suit injunctions before you spend all of that $5 million pot. So it is a weapon that I think is sometimes too quickly overlooked and should be deployed in any case where there's any significant exposure. The second way is the ability to go and issue arbitration proceedings in London and obtain an award for damages for breach of the arbitration agreement. If you have a congen bill incorporating a law and arbitration clause, an identified charter party with an English law and arbitration clause, then it is settled law in England that the contract of carriage is subject to English law and London arbitration. And if you were to bring proceedings elsewhere, then you are breaching that agreement to arbitrate in London, and there will be liability for damages for that breach. And if you are bringing proceedings in China, then you're in flagrant breach of that. We have on 2 or 3 occasions taken this through to its end and obtained awards against the Chinese receivers for the full amount of any judgment that has been issued in China, plus all of the legal costs that we've had to incur in China in defending the claim, and plus, interestingly, the costs of posting the guarantee in China. That can be claimed either as damages for breach of the arbitration agreement, though that is perhaps a slightly more difficult basis, or alternatively as costs of the action, relying on the first instance decision of Mr. Justice Andrew Smith in the Goss. The Goss, of course, is a well-known case and the leading case now on implied indemnities, but there's a lot more in it than that, and I would commend you to read the first instance decision. Of course, you might say to me, well, what use is an award against a Chinese receiver whose only assets are in China? Well, that assumes, of course, firstly, that their only assets are in China. As the Chinese economy grows as Chinese group companies become more global, there are more and more Chinese assets resting overseas. There may well be many Chinese receivers whose only assets are in China. And I'd be the first to acknowledge that enforcing that award in China is not going to be possible. But I think one of the reasons why anti-suit injunctions are complied with now is because China is more global. I've always scratched my head slightly and wondered why, when we get an anti-suit injunction, the 10% comply. I can only assume, but I'm probably wrong about this, that more and more CEOs of Chinese insurance companies have their children boarding school in the UK and don't want to be in contempt of court. As more and more Chinese pupils populate our schools here, then perhaps this tactic of getting an anti-suit injunction will increase statistically in line with the population of our public schools here. Anyway, that's an aside. But damages for breach of an arbitration agreement is not always a toothless tiger. And if you have a Chinese receiver who does in fact have assets overseas, then it can be quite a useful tactic. The other very emerging line of attack is to bring proceedings against the Chinese underwriter in arbitration for breach of the arbitration agreement. And spearheading this development is Alex Wright, and we're lucky to be sharing the panel with him. So rather than steal his thunder, I'm going to just flip across for a couple of minutes to Alex to ask him to explain to us how the Frio Dolphin came about and how it can be used in this context.
Thank you very much, Darryl, for that very kind introduction, and also to Anna for organising this seminar together with Aleka's team at the LSLC and Francesca's team at YMP. So I'm going to speak briefly about Frio Dolphin, then hand back to Darryl to round off this section on potential actions against receivers and cargo interests. And then I'm afraid you've got me again for recourse actions against the chartering chain. But in terms of the Frio Dolphin, it wasn't a soybeans case as such, but clearly a lot of the legal principles that it establishes are likely to be applicable in soybean cases against cargo underwriters. The case arose out of the shipment of a cargo of frozen seafood, and it was outturned in Spain and found damage on outturn. The bill of lading incorporated in the usual way English law and London arbitration provisions, but what happened was that the Spanish cargo underwriters brought proceedings in Spain, in fact, against the owner's managers for reasons that we could never entirely understand, whether it was an innocent mistake or an attempt to outflank the arbitration agreement. But be that as it may, that is what happened. And immediately that defanged two of the possible avenues of recourse that Darryl has outlined. This was a pre-Brexit case, and therefore there was no scope for obtaining an anti-suit injunction to restrain proceedings in another EU member state, pursuant to the rule in West Tankers. And because the Spanish proceedings had been commenced by the underwriters, there was no sustainable basis for claiming damages against the receivers themselves for breach of the arbitration agreement. So that left us with a bit of a conundrum. Fortunately, the Spanish court, the Spanish appellate court, declined jurisdiction, and so there was no exposure to the substantive claim, but there was still quite a considerable exposure in terms of irrecoverable costs. And so that formed the basis of our attempt to obtain recourse against the cargo underwriters. We were assisted immeasurably by the fact that the underwriters themselves, having failed to establish jurisdiction in Spain, then made themselves one of the claimants in London arbitration. So that got us over any potential jurisdictional difficulty. I think now there may be argument for saying that you could invoke jurisdiction under the rule in the Prestige, but that is a debate for another day. But fortunately, it didn't arise in our case. The cargo claim itself, we eventually got struck out for inordinate and inexcusable delay and/or because it was time barred, and that left the counterclaim for the irrecoverable costs of the Spanish accident. Both before the arbitrator and then on appeal to the commercial court under section 69, where we were before Sir Michael Burton, it was established that we did have a cause of action sounding in monetary relief against the cargo underwriter. And the basis for that was the first part of the analysis was the long-standing principle of English law that where an underwriter seeks to invoke rights derived by subrogation, it is, at least to some extent, bound by the arbitration agreement. So it is obliged to arbitrate that dispute. And there's a long-standing series of authorities that holds that you can injunct any proceedings that are brought in breach of that arbitration agreement, subject, as I say, to the wrinkle here that this was a claim brought in an EU member state. But again, in principle, if, for example, taking us back to soybeans, a Chinese underwriter commenced proceedings in a Chinese maritime court, that could be restrained by injunction in the same way as it would be if a receiver had brought the action. So that was the first part of the analysis. The second part of the analysis was relying upon a decision of Lord Justice Mayles in a decision called Airbus and Generali, which established that the nature of that obligation was indeed a substantive obligation. And then the third part of the triangle, if I can put it that way, was the decided for the first time in the Frio Dolphin, which is that in circumstances where there was a substantive equitable obligation to only bring claims in accordance with the arbitration agreement, that is something for which equitable compensation could, and in our case, should be ordered. So we were indeed able to obtain an award against the cargo underwriters. There was one additional wrinkle, which is, as I mentioned, the claim was brought against the owner's managers, but we were nonetheless able to recover those costs on the basis of transferred loss. An appeal had been heading to the Court of Appeal in January of this year, but that was compromised by the parties. So certainly at first instance level, and I don't know whether in due course another underwriter might fancy taking its chances up to the Court of Appeal, but at first instance level, the settled position is that you can now obtain equitable compensation against an insurer that brings proceedings in a jurisdiction other than that catered for in the forum clause. So it is quite a useful additional weapon in the armory of owners and owners' interests facing cargo underwriters. So I'll hand back to Darryl now to talk about economic torts.
Thank you very much, Alex. Yes, I think it's a powerful weapon. I had long been looking for how I could proceed in arbitration against cargo underwriters, and in fact had received advice that I couldn't. So Alex has found a way through, and the law seems to be supporting him with the development in the prestige. But because I, in a case that I've had running now for about 10 years, couldn't find a way through, we had to look for a different way. And we issued in the English court a claim form against a Chinese underwriter for the economic tort of inducing a breach of contract. We said it was the Chinese underwriter which was the guiding hand behind the Chinese receiver in arresting the ship, requiring security that at least responded to a Chinese court decision, and then ensuring that the Chinese receiver pursued that claims through the Chinese court in face of an anti-suit injunction. And we were able to serve that claim form out of the jurisdiction on the Chinese underwriter because one of the gateways is a claim in respect of a contract which is governed by English law. And there are many cases which interpret in that context what in respect of means, and the courts have given it a wide interpretation. And so I think, although you'll have to take advice if and when you pursue this course of action, I think it could be construed as if it said in connection with. So our claim is a claim in connection with a contract governed by English law. We obtained permission to serve out from Mr. Justice Leggett, who he was then. Of course, he's now moved up to the Supreme Court, so we've got some pretty good pedigree on the ticket. And we served the claim form. There was no acknowledgement of service. We eventually have a judgment, and we are at the moment trying to enforce that judgment. So I can't tell you how we're getting on, but we have found some assets of the Chinese underwriter. And if we're successful in enforcing, then we'll be able to cancel out all of the pain that we suffered in China. The final, of course, recourse is under the ICA against the charterers. The Yahtzee High, when it came out, of course, has caused a great deal of excitement among ship owners who now often tell you that simply because you ordered the vessel to load a cargo of soybeans, that you're, as the charterer, now 100% to blame. I think that argument was put forward in submissions to the Court of Appeal, and both Longmore and Hamblin were pretty dismissive of it. Of course, in the Yahtzee High, there was the added aggravating factor of the charterers having ordered the vessel to wait off of Iran pending payment, and it was the delay waiting off of Iran that was also causative of the soybeans spoiling. So I think under the ICA, the simple order to load is not going to be enough. And if that's all you have, in my own view, that's a 50-50 apportionment of liability. If you have other factors, such as in the Yahtzee High, then of course, as we now know, it doesn't have to be a negligent act. It merely needs to be an act for you to invoke that provision. But don't forget, you need clear and irrefutable evidence, which in itself is not an easy threshold to overcome. So it's an important ingredient that one must bear in mind. Of course, in Chinese ports, you'll often face congestion at the discharge port, and it might be said that if you have a 30-day congestion, that additional delay is tantamount, if you like, to a Yahtzee High type delay. I think this requires careful analysis because one has to look at what obligations a time charterer owes under the charter party. Is it really the time charterer's obligation to take delivery of the goods? Of course, it's his obligation to discharge the goods when the time comes to discharge the goods, but is it his obligation to take delivery of the goods and arrange for delivery to be taken promptly upon arrival? I think the answer to that is not. So it remains to be seen how that would be decided. We now know that a time charterer who might incur liability for delays for damage caused by delays at a discharge port will have no recourse against a voyage charter under the Court of Appeal decision of the Eternal Bliss. I should say for now, because the permission to appeal is being sought from the Supreme Court, and we're yet to find out whether it will be granted. So there is, to some degree, hope for owners yet, but as the music stands, it will be quite difficult. So I think that's really all I wanted to say, but I know that many of the panelists have their own views on the ICA, and Ben, I wonder if you want to add anything to what I've said on the ICA.
Yeah, thanks, Darryl. Sure, I agree with most of what you've said, if not all of what you've said. I've had some experience of the ICA in the context of soybean arbitrations. I can highlight a couple of other issues that have arisen, and partly out of the fact, I suppose, that that the ICA was actually drafted and intended initially to be a document, an agreement between P&I clubs, governing relations between P&I clubs rather than charterers and ship owners. But actually, it's increasingly and invariably incorporated into charter parties, and and governs the the relationship, the contractual relationship between owners and charterers as well. So when that's one issue that I've seen in a soybean arbitration is the language of incorporation. If often the clause is based on an old pro forma charter party that's maybe not been kept up to date, and the language of incorporation of the ICA is not actually that clear, such that the parties can spend considerable time disputing which version of the ICA applies. So language of incorporation of the ICA is it can be and is something to look at and bear in mind. Also, the types of claims that come within the scope of the ICA. It's not that there's a definition of a cargo claim in the ICA, but it's not prescriptive about what any sort of qualifying claim must in fact include or concern. So it doesn't state that there must in fact be damage or loss, or it must in fact be proven or established. So when an allegation is made and the case is settled before a decision is handed down or liability is established, is that sufficient simply to allege damage, or must damage actually be established? A question that was posed to me before this event was if subcharterers withhold freight. Well, actually, I'll bring Ian Clarke into this too, because I think he has an answer to this. But the question is, if a subcharterers withhold freight as security for a cargo damage claim, is this a claim that can fall under the ICA terms in the head charter? I mean, I tend to think that deductions from freight are governed by the terms of the voyage subcharter in the first instance, but that's maybe not the complete answer. Ian, do you want to jump in and take that one?
Yeah, I think that in terms of the sub-voyage charter, a deduction for a cargo claim, unless it has been specifically agreed that deductions can be made from freight, it's something which would be wrongful on the basis of the Aries decision, which says that freight is indefeasible. Of course, that doesn't mean to say that parties don't go and do it as charterers, and when they manage to hold that, withdraw that freight payment, they are indeed holding a bargaining position that they are going to try and use. And of course, that reflects through into the charter party up the chain, which will say there's only one as a time charter, and it can be very difficult. There's still an obligation for hire, etc., to be paid to the ship owner, and for the disponent owner to then say, I'm not paying, or because I've not been paid the freight down the line, isn't really a good enough reason in my view. Whether a cargo claim can be offset against hire is going to be an interesting question, and partly that will depend upon whether there's a right of set-off in the charter party, or indeed if there's a right of equitable set-off. I don't believe that this is likely to be something which is arising for equitable set-off quite so readily, but of course every case will turn upon its own facts. One thing, of course, an owner may look to do in this circumstance is where deductions have been made, is to look to see what leverage they have back and whether they can exercise a lien over freights or over the cargo itself. Although whether you want to exercise a lien over a decaying cargo may be something which shoots yourself in the foot. So all of these things will have to be taken quite carefully. And as to how that would fit into the ICA, I think will really depend upon how any claim is framed in the first instance. But of course, the owner is still on the back foot with having to foot the claim primarily with the claimants. So it's trying to engage all the parties within the chain is probably an imperative to try and look for, because of course the sub-charterers have got a greater proximity to the sale and purchase contract, and if you can try and resolve some of the issues between the buyer and the seller of the cargo, that's more likely to then have a knock-on impact at the charter party chain and try to see things get resolved. So a long answer and not a complete answer to very straightforward question.
Thank you, Ian and Ben. That's really useful, and thanks for tackling that question. I think that leads us very neatly into charter party disputes, and Alex has kindly prepared a few slides on that. So if we could move into that now, please. Thank you.
Thank you very much, Anna. Just before we get on to recourse against charterers, I've had a question about the Frio Dolphin. I think someone has asked whether there is any basis upon which subrogated underwriters can be removed from an arbitration in which they have named themselves as claimants together with the receiver. The English law position is that subrogated underwriters don't have title in their own name. They must bring any claim in the name of their assured, effectively. So the proper claimant would be the assured. In the Frio Dolphin, there was in fact a strategic advantage to the insurers being party to the arbitration for the reasons that I've outlined. In most cases where both the underwriters and the receivers are named, it will rarely be of any great advantage to seek to remove them. And there may be circumstances where in fact it's better for owners to have them as party to the arbitration, in, for example, the Frio Dolphin, but also, for example, in the context of enforcement of costs awards. So I think the answer to the question that's been put is that theoretically, a subrogated underwriter, unless you're in a Frio Dolphin type situation, should not be named as a claimant in an arbitration, but it would rarely be an efficient use of resources to try to remove them. If I can move then on to charter parties and perhaps the next slide, Anna. We've seen that soybeans are highly susceptible to damage and deterioration, and as the other panelists have explained, you will often have a situation where claims are made against owners that they are either held liable for or have to settle, and that they will then seek to recoup that liability from charterers. And Ben and Darryl and Ian have touched upon the ICA. I don't want to add to the chorus of voices on that. I want to look at, first of all, potential recourse against time charterers under the implied indemnity, if for whatever reason the ICA is not incorporated, and that may well be an alternative basis for recovery, although there is still some uncertainty about its scope. And then I want to contrast that with claims against voyage charterers, which, as the law stands, is much more difficult. And in both the Tide Prize and the Eternal Bliss, which in a way are fairly template soybean type claims, with shipments from Brazil to China, damage found on outturn, and as a result of that, owners being held liable or settling with receivers and looking to obtain recourse down the line. So those are fairly typical template soybean claims. Different formulations were advanced to try and seek some recoupment against the voyage charterers, but both of them, certainly as the law currently stands, failed. So if we look at time charters first and the implied indemnity, and as many listening to this talk will know, there is usually in a time charter, unless there's an express indemnity, but for example, on the NYPE form, there will be an implied indemnity against loss or damage suffered or liability incurred by the owners as a consequence of complying with charterer's orders or directions, unless by the charter the owners consented to bear the loss, damage or liability in question. And as you will see from the second bullet point, the two real limitations on what is otherwise a very wide indemnity are firstly causation. So it has now been established at Supreme Court level that the order or direction must be an effective cause of the loss. And there had previously been a question as to whether or not one had to look for the effective cause or the dominant cause. But post the Goss, it has now been established that an effective cause is sufficient. So in context of soybeans, you might have a situation where there's a combination of causes, both pre-existing damage, but also actions by third parties, and it might be the costs have been argued that the actions by the third party receivers operated to break the chain of causation. For example, if it's an exaggerated claim, but post the cost, it is very difficult where a contaminated cargo has been loaded on the orders of the time charterers for them to escape responsibility on the causation limb. The second is whether or not owners have contractually accepted the risk of incurring the loss. And that is a proposition that is easily stated, but is in a way the most difficult, I think, to apply on particular facts. And in particular, I've seen quite a few cases recently on this question as to whether or not owners are taken to have positively accepted all foreseeable risks associated with ports and cargoes that they have agreed to trade or to carry. My view is that in certainly a period time charter with worldwide trading, the answer to that question is probably not. Certainly as regards types of cargoes, there's a fairly strong steer from that in the Athanasia Komnenos, the decision of Mr. Justice Mustill, as he then was, which has been approved at appellate level on several occasions. That was the case, many of you will recall, where an explosion was caused by the ignition of methane emitted by coal. The coal was not dangerous or even unusual, but nonetheless, Mr. Justice Mustill held the time charterers liable in one of the two conjoined cases for the simple reason that methane was in the hole because they loaded coal pursuant to the wide liberty that they had under the employment clause. And he said that this answer is, in my opinion, sufficient to found an indemnity without proof that the coal was in any way unusual. So that's the position as regards cargoes. As regards ports, the position is perhaps less clear. The Island Archon, of course, which is now regarded as one of the leading modern cases, had the, and I don't think we're quite onto voyage charters yet, sorry. The Island Archon had the unusual feature that the Iraqi system of bogus cargo claims was known to the charterers at the time the order was given, but not as at the date that the charter party was entered into. So where there is a system of invariably bogus cargo claims, one is squarely within the Island Archon. Where one has a situation where exaggerated or spurious cargo claims are made, but not systematically so, then there is more room for debate. But again, my answer would be that where you have a wide liberty as to ports of call, that is a risk that falls upon the charterers rather than the owners. And I think that's consistent with certain dicta in the Island Archon and a learned article by David Foxton QC, as he then was, in the 2008 publication, Legal Issues Related to Time Charter Parties. I would contrast that with trip charters. So in the paradigm case, again, bringing it back to soybeans, if you had a trip charter for carriage of a cargo of soybeans from Brazil to China, in those sorts of situations, you would expect owners to have consented to bear the risks associated with the carriage of that particular cargo from those particular destinations and discharge ports. So there, I think there is a much narrower approach to the implied indemnity. And again, I referred to a couple of dicta which support that. But I guess because a lot of these cases are in arbitration, there is room for debate because there is very little specific authority on that sort of issue. Although, as I say, there is some dicta that points in a particular way, both in the Island Archon itself and a case called the Doric Pride. If we go on then to voyage charters, please. The first of the two cases I want to talk about is the Thai Prize, which is a Brazilian soybean cargo that was shipped to China. Ian's just... Yes, I think Ian has made the point that the claims were brought against the ship owners, and so these are all concerned with recourse actions where an owner has either had a liability to the receivers or settled that liability and is then seeking to recoup down the line, just to make that clear. So the tie prize, shipment of Brazilian soybeans in bulk. The cargo was loaded in a draft bill of lading presented to the master for signature, which referred to the cargo having been shipped in apparent good order and condition. On outturn, the cargo was found to be damaged due to inherent vice, but nonetheless, the head owners were found liable to receivers by the Chinese maritime courts, and they sought a recoupment under the ICA from the disponent owners, which was compromised. The disponent owner time charterers then sought to recoup that sum from my clients, the voyage charterers. In arbitration, it was found that because the contamination at the load port was not apparent to the master, but that it ought to have been apparent to the shippers, the draft bill of lading as presented was inaccurate, because the arbitrator's view was that that contained a representation on behalf of the shippers that there were no defects that were apparent to them. And the arbitrator went on to find that the voyage charterers are either warranted or implicitly agreed to indemnify the owners against the inaccuracy in that draft bill. We successfully overturned that award in the commercial court before Judge Pelling, and then a further appeal by the disponent owners against Judge Pelling's decision that the Court of Appeal was dismissed. I've set out on the slide the crux of the issue as summarised by Lord Justice Mayles. A bill of lading will generally state that the cargo has been shipped in apparent good order and condition. That refers to the external appearance of the cargo so far as meets the eye on a reasonable examination. One of the questions raised by this appeal is apparent to whom, and following existing authority, the Court of Appeal upholding Judge Pelling on this held that apparency was to the master, and in those circumstances the bill was not inaccurate, and the voyage charterer gave no representation and no indemnity concerning the apparent order and condition of the cargo when tendering the draft bill. The one interesting question which is left open, and my opponent James Evy's QC made a very forceful argument that one of the dangers of the judge's approach was that it meant that, at least in principle, you could have a dishonest shipper who was trying to pass off a cargo that he knew to be defective and effectively hoodwinking the master into signing a clean bill in circumstances where it was not apparent to the master that this cargo was defective. But as you will see, and I won't read it out, but at paragraph 57 of the judgment, the Court of Appeal left open the possibility that where a shipper has, or I suppose by extension a charterer has actual knowledge that there are defects in the cargo, then in those circumstances there may be some sort of implied representation in the tendering of a draft bill that records shipment in apparent good order and condition. But that is a matter that didn't arise on our facts and will have to be decided on another day. So that's the tie prize. If I can move on briskly to the eternal bliss, and again, a fairly template soybean case, cargo of Brazilian soybeans shipped to China pursuant to a long-term contract for affreightment. There were extensive delays due to congestion at China, and it was assumed for the purposes of a preliminary point of law that that delay led to the spoliation of the cargo. And a further important assumption was that although charterers were therefore in breach of their obligation to discharge within lay time, there was no other breach of the voyage charter. The issue then arose as to whether or not that breach, i.e. the failure to discharge within lay time, was a breach that would allow owners to recover liability to the receivers, or whether in circumstances where my clients have paid demurrage in full, that fully liquidated all of the losses stemming from that breach. So, as I've set out in the first bullet point, and Mr. Justice Andrew Baker at first instance considered whether or not the issue that he considered was whether or not demurrage liquidated all losses flowing from that breach, or only loss of freight and other earnings. At first instance, Mr. Justice Andrew Baker found for the owners on the basis that demurrage only liquidated the loss of freight earning, and a cargo claim therefore sat outside that. But that was reversed by the Court of Appeal, approving the early decision of Mr. Justice Potter, as he then was in the bond. And so as matters stand, it is necessary for owners to prove a separate breach separate from the law as it stands. As Darryl has mentioned, there is a pending application for permission to appeal to the Supreme Court. So who knows where we'll be in a couple of years' time, but that is certainly the position as we are today. So in terms of the key takeaways, and if I can just wrap up, recovery action may be possible against time charterers even when the ICA is not incorporated under the implied indemnity. That is a course of action that is likely to be more promising in the context of a long-term period charter with wide trading limits and choices of cargo. It may be much more difficult in the context of a single trip charter. As against voyage charters, the position is much more difficult, and attempts so far to hold voyage charterers liable on different bases have failed in both the tie price and the eternal bliss. But again, there is a chink of light potentially for owners on both cases. Firstly, in relation to the tie prize, if it's possible to prove actual knowledge on the part of the shippers or charterers as to pre-shipment damage, and as regards the eternal bliss, as I say, there is this pending application for permission to the Supreme Court, so we'll have to see what happens there. Thank you very much indeed, and I think am I handing back to Hannah for.
Yes, thank you so much, Alex, and everyone. Really, it's been a fascinating whistle-stop tour through so many different areas in these types of cargo claims. We've heard about the practical issues, about the trade volumes, about practical tips, about the arbitration agreement, and the armory for ship owners, and very interesting cases that Alex has now shed some more light on. For your dolphin, tie prize, and the eternal bliss. What I really wanted to do now is take some time to answer more questions. We've already started, we've answered some questions that were sent before, but now is really the time for the participants, and we still have a good number of them. Thank you for sticking with us for such a long time, to ask questions in the Q&A box or in the chat function. And I think I'll just give them some time to type out questions and see if we can help with some of those.
Maybe I'll ask a question of Ian whilst people are thinking of their questions. Ian, what's the approach of the West of England towards anti-suit injunctions? Because I think there is a bit of a mixed feeling about them, because of course you guys have to pay the costs of the lawyers going in. So it's all very well for me to say we should do this, and you know, as I've said, very often they're ignored and maybe are in vain, but occasionally they hit the jackpot. What's your thoughts?
Well, we try to take each case on its own merits, and very often, I mean, we may even be insuring the charterer in these instances. We don't always wear a ship owner's hat working for a P&I club, so we're quite appreciative of the issues that can arise between owners and charterers, and how the relationships may need to play out. What we will very often do is we'll put up, for example, I'm on the owner's side, we may put up security for the best part of $10 million for one of these types of claims. We will have an engagement with the charterers, try and get security back from them. Hopefully they're within an IG club, and it's a little easier for us to be able to engage in that dialogue, and there are greater obligations upon the clubs. And then we can start looking at the claims themselves. And of course, as I mentioned, we're looking at the real quantum of claims, how it may play out in China. And then with regard to the ICA, we'll have a discussion with the charterers. And if we both believe that we're effectively on a hiding to nothing, then we may have an agreement between ourselves that we're simply not going to bother with it. Yet at other times, it may be a good idea to be able to do it because the charterers will say, actually, this helps us give us further ammunition to be able to negotiate further down the chain, minimize the claim, and effectively minimize the exposure that that charterer will have. So we have actually quite a consensual dialogue generally with the charterers, particularly if they're within another IG club. Alternatively, we may have radio silence from those charterers, and then we'll take an anti-suit under advisement. And it may also depend upon which maritime court in China you're looking at. We know that the variations, for instance, within the different maritime courts as to what trade tolerance they may apply, if any at all. So, variations upon the theme, and we'll take close legal advice as to whether it's worth it. But I take the point that you made earlier on, Darryl, that spending a few $1,000s on an anti-suit injunction, even if it is not necessarily going to be wholly effective, can be money quite well spent in certain occasions. So we'll try to pick our battles carefully.
Thank you, Ian. And in the meantime, I think we have received a question on the Hague-Visby rules. One of our attendees has asked in the Q&A section, please confirm my understanding. The owners are liable for deterioration of a cargo of soybean meal unless they can bring themselves within an Article 4 Rule 2 exception, even if the cargo was loaded with a slightly elevated moisture content. So, for example, if delay caused by unseaworthiness of the ship and cargo would otherwise have arrived okay, but for the delay. Anyone wishing to briefly tackle this situation?
Yeah, I'm happy to step up to the plate. I think the first, I think the question probably stems from the question of where the burden of proof lies, and VOLCAF. VOLCAF, of course, was all about the owner having the burden of proof if the cargo is damaged during the period of transit, of establishing why that loss or damage occurred without his fault. But most cases are not generally about burden of proof. There tends to be there tends to be evidence which leads to a particular cause. In any case where the vessel was unseaworthy at the commencement of the voyage, the ship owner is likely to be liable because he won't be able to have recourse to his Article 4 Rule 2 defences unless he can show he exercised due diligence, and notwithstanding that due diligence, the vessel was unseaworthy. But as was once said by one of the judges, I forget the judgment, but it's certainly cited in the Eurasian Dream, if due diligence had been exercised, the vessel wouldn't have been unseaworthy. So that's not quite a true statement, but it does give you a sense of the very high threshold that you'll have to overcome if you're going to fall back on the due diligence aspect of a defence. So I think unseaworthiness, no, it's game over for the ship owners in most cases. If there's no unseaworthiness, then there can be defences of errors of navigation and management of the ship, but you can never invoke error of management when it refers to management of cargo. It's management of the ship, not management of your duty to care for the cargo. But if it is inherent vice, the vessel was seaworthy, there has been no failure to properly care for the cargo. Yes, VOLCAF might say you've got the burden of proof of establishing why the loss arose without your fault, but you can explain that it was the inherent vice or the characteristics of the cargo which led to the cargo deterioration, that you ventilated the cargo appropriately, or that ventilation wasn't an effective cause because the deterioration was deep in the stow, and ventilation will only affect the headspace and the surface of the stow. And in that case, you will have established that there was no fault on your part as a ship owner, and that the loss occurred by some other reason, and you will have discharged your burden of proof.
Thank you, Darryl. We have two further questions. I think that's also all we have time for now. One quick question, hopefully, and I think Ian Gaunt might be well placed to answer this. If the name of the parties is required on the front of the bill, what is the position if the consignee is to order? So I think this refers to the bit about having the name of the parties on front of the bill.
I don't think there's any clear answer to that, short of a case actually being brought before the Chinese courts. But there is, I think, a strong antipathy on the part of the Chinese maritime courts towards incorporation of arbitration agreements. I think there is a strong wish to retain jurisdiction in the maritime courts, and therefore I think unless you fall pretty squarely within the terms of the direction or the opinion which is being given by the Supreme People's Court, there is definitely a risk that you are not going to establish the criteria which are needed in order to be able to say that the arbitration agreement has been properly incorporated.
Thank you so much, Ian. And last question to Ian Clarke.
Well, I think all of our owners believe that every claim that's made against them is an obvious injustice. But that aside, the currency of the clubs are our letters of undertaking. We always have to abide by whatever we've agreed to. Come hell or high water, we agreed to it, and provided that the terms of that undertaking have been complied with, for example, if the case is, is a full and final judgment, etc., or a reasonable settlement, then we will always pay out. Not to do so will dent our credibility and that of the rest of the P&I clubs and other insurers in the market. So much as it sometimes pains me to have to pay out under these undertakings, we always will do.
Thank you, Ian. That's a very reassuring note to end on. I think that's a wrap for us. I should thank again very, very warmly the panel, of course, all the speakers for sharing their time and expertise with us. Thank you also to the audience. We had a remarkable turnout. It was very good to see you all here virtually, and we will send around the slides, and please send any further questions that you may have that you feel that weren't answered. We hope to have helped you with some of these tricky issues. And it was great to see so many of you here. And of course, a very warm thank you also to the London Shipping Law Centre and the young maritime professionals for co-hosting this, specifically to Francesca Kappa and Dr. Aleka Shepherd and Jared, who've been really instrumental in putting these on, and also to For Pump Court for co-hosting this. Thank you all, and have a really lovely afternoon, everyone.
Thank you, and thank you for organising. Thank you.